SJC-10243 Pixley versus the Commonwealth.
Good morning, Ms. Ross.
Good morning, members of the court. My name is Jane Ross, and I represent Marcus Pixley in this matter. The issue before the court is whether appellate counsel has a right to have a copy of an in-camera hearing that was conducted at trial.
I have a question. I'm going to ask the same question of the other parties, the other counsel. Have you been, well, I assume you've been practicing criminal law for some time, or for
Yes.
an adequate amount of time to have some experience. Have you ever heard, other than in the Martin case, have you ever been aware of a Martin hearing being held?
When I was in Superior Court, I actually got appointed to represent a witness and did a sidebar conference with the judge. It was a while ago, but I think it was Judge Ball also.
It happens not infrequently in Suffolk County.
I'm not talking about just and was the defendant present in the courtroom?
When I did it, it was just me and the judge at the sidebar.
So, but I mean, defense counsel. What I'm talking about
No,
is
she wasn't. She was appointed for the witness. Is that right?
I was,
you were
yes,
appointed
I'm
for the
sorry.
witness.
did
So
I-
I'm sorry. So the
I was
defendant
appointed
wasn't
for the
present.
witness, to
Nobody was
represent
present.
the witness
And it
interest.
wasn't done in open court.
Not at all. No, it was not.
And this is once it happened. Okay.
Right.
Okay.
In our case, in the Pixley case, that's what happened. Well, what happened was that the hearing was conducted, I believe, at the sidebar, and present was the attorney for the witness.
If you, let's assume that I think this is the Commonwealth's suggestion that the appellate court could, I think this is right, review the transcript of the Lumen Martin hearing and make a judgment on the basis of that transcript without the parties arguing the point. I mean, obviously somebody would have to raise it, but could make a judgment on the basis of that transcript as to whether the judge abused his or her discretion or not in granting the letting them assert the privilege, letting the witness assert the privilege. And I think an argument is made, well, you know, that's sort of what happened in the whole Bishop history, which ended with Dwyer, you know, where counsel gets to weigh in. And I guess my question is, isn't this really a sort of distinct area in that whether or not a particular person can claim a valid privilege is really a question of law, isn't it, based on what's said? In other words, isn't this a situation where it may be easier for a court, minus the arguments of counsel, to make that judgment than is true in terms of whether particular records should or shouldn't come into evidence in a sexual assault case?
Well, it places the appeals court in the position of not being a neutral arbiter.
What do you mean?
Places in the position of being an advocate.
Why?
Why?
Put it this way. Unlike the Bishop Fuller situation, in that case, for example, you know, the one that we kept getting raised with, a judge may not know and an appellate court may not know whether the fact that the alleged offense occurred on September the 10th made any difference, because the judge may not be aware of the fact that on September the 10th, you know, the made a difference. I think that was one of the cases. In this case, it's got nothing to do with the defense. I mean, the defense, of course, wants the testimony, but the only issue here is the right of the witness vis-a-vis the state. That's all. That's all. And if there's a basis for the witness to assert a Fifth Amendment privilege, that's either established on the record or not established on the record. It might be the defense counsel could have asked some different questions, but that's not the point. It's got really very little to do with the defense lights. It has to do with the witnesses' lights.
Well, that's true if the case is that it's the Commonwealth's witness. And in our case...
No,
this,
it's any witness.
Well, with regard to whether...
I understand that you have a right to call whatever, you have the right to present facts that you want to present, but as to whether you can present certain facts is really a determination, as I said, at least it seems to me, between the witness and the state.
I'm not sure.
Are you saying that the Fifth Amendment rights, that the defendant's right to a fair trial trump the Fifth Amendment rights?
The defendant has a right to present all relevant evidence
That trumps or doesn't trump the Fifth
that's
Amendment?
not privileged.
So you can see that the privilege trumps the defendant's right to a fair trial, based on what you just said.
Well, the situation is that when it's the defense witness, the defendant does have, this is a critical stage because the judge is going to be determining whether or not the defendant is going to have a right to present the defense. This is definitely evidence that's going to be exculpatory. It's a defense witness, okay? It's different than the Bishop Fuller situation because those are pretrial records. And at that point, the
It's
judge...
also not a Fifth Amendment privilege.
Pardon me?
It's also not a Fifth Amendment privilege.
Right. But I mean, the analogy of the judge, the trial judge, reviewing the records is different than a situation of the defense attorney being allowed to participate in a stage of the proceeding where he has evidence that's relevant, and the judge is going to make a determination whether or not the defendant can use that relevant evidence.
But, Ms. Ross, we're not arguing here, we're not sort of going back and revisiting Lumen Martin, are we? Aren't we trying to figure out what is the appropriate way to appeal from a decision by a trial judge who has decided that a particular witness has a privilege? I mean, are you questioning the Lumen Martin protocol itself?
No, I'm not questioning the Lumen Martin protocol, but what I'm saying is that this particular situation, when it is a defense witness, this is the only situation where that would present an appealable issue. If it's the Commonwealth's witness, the defendant has no standing at the Martin hearing.
Why?
When it's the
I
Commonwealth's
understand
witness...
What's the difference? Why are you drawing a distinction? I understand that usually these witnesses who claim the Fifth Amendment are Commonwealth witnesses. Typically they are.
Right.
But why are you drawing a distinction between who's calling the witness?
Because if it's the Commonwealth's witness, what the judge rules with regard to the Fifth Amendment privilege, the defendant has no standing to object to it one way or the other, because the Commonwealth has got a right to put on their case. And if the judge rules that the witness has a Fifth Amendment privilege, then it's up to the Commonwealth whether they want to seek immunity for this witness or not. If the judge rules that the Commonwealth witness does not have a privilege, then the Commonwealth presents the witness at trial. So it never presents an appealable issue.
Yeah, I don't think that's your principal point, but that's not necessarily true. There's some instances where a defendant is just chomping at the bit to get at a Commonwealth witness because there's stuff that's going to come out on cross-examination that's going to be the defendant's whole case.
Right, but the defendant doesn't have a right to object to the judge ruling that there is no Fifth Amendment privilege and that the witness
So what
has to
makes it
testify.
different when it's a defense witness? That's what I'm asking you.
Well, what's different about a defense witness is that it's evidence that the defendant has already, it's exculpatory evidence. The defendant has a right to his defense. It's clearly relevant, and the judge is going to be making a decision based on whether the witness has a Fifth Amendment privilege or not. But the effect of that decision is to either allow or to deprive the
Okay.
witness of presenting exculpatory evidence.
All right, let me ask you this. Why isn't this an issue that should come up, as Justice Cordy ruled, as single justice, in the normal course? Why isn't this just like a motion to suppress where the defendant loses, so he's killed because the confession comes in? That's really the whole case. And yet we say you have to wait until after there's a conviction to appeal it. Why shouldn't this be the same way?
Well, because the status of the case right now is that the defendant has been convicted, the appeal is pending in the appeals court, The post-trial motions that the defendant filed, the first one allowed counsel, me, to read this impounded transcript, which I have done. And when I made the motion for further orders regarding disclosure, and it's denied, and that petition was also...
But why shouldn't that issue all be resolved in your appeal that's now pending, I guess, at the appeals court? And then if you lose there, or whoever loses there can seek further appellate review. Why isn't it just the same as anything else?
Well, because I'm now in the position of not being able to argue that issue on appeal, that the judge's ruling was invalid. In fact, that the witness did not have a Fifth Amendment privilege. There's no way that I can argue it, because right now...
Can't you file a motion in the appeals court asking for access to that transcript?
She's seen it.
I have seen it already.
Yeah. By virtue of a superior court order or an appeals court order?
By virtue of a superior court order.
Okay, so now can't you file a motion in the appeals court to get access for purposes of incorporating that into your appeal? I mean,
Well, the issue hasn't been addressed.
Isn't that what they did in the old Bishop Fuller cases on appeal, when there were things that were set aside?
But,
and then if you
but
need
this
to
is
refer to
different.
them in your brief, once you've gotten access, if you get access, that you ask that the brief be impounded.
Right, but if the appeals court were to deny that motion, then I'd be in the position that I am today.
Well, but they haven't denied that motion.
No, but we did take the route of filing a 211 Section 3 petition. We did that instead of going the other way. But if we were to do that, and if it were denied, then, like I said, I'd be in the same position that I am today, being unable to argue that issue.
Mrs. Lost, maybe it's late in the morning and I'm tired, but I'm really trying to get to the basis of... I understand you have a right to present evidence. I can perceive why you draw a distinction, although I think Justice Spina has a point that sometimes a Commonwealth witness that the defendant hasn't wanted to call may be very helpful to a defendant. Nevertheless, if the judge in the trial court conducts a colloquy, and that is recorded, and the appellate court has an opportunity to review that to determine whether, as a matter of law, there was sufficient to conclude that the defendant had exercised, properly exercised his Fifth Amendment, or the witness had properly exercised his Fifth Amendment right, what further interest does the defendant have, unless you were to claim that the right to a fair trial, which is an important right, trumps a Fifth Amendment?
Not based on my brief, but based on the brief of the
CPCS.
amicus brief. The position is that the defendant had a right originally to be
Correct.
at the hearing.
They want the defendant to actually listen to the evidence and have
Yes.
a right to cross-examine and to participate.
Right.
But then what happens to the Fifth Amendment privilege?
Well, it's not
gone from-
it's not violated if the defendant is present, because the interest that the witness has is in preventing the prosecution from learning
I know,
of
but
any
that
potentially...
could be a problem. But what do you think of the suggestion, I think CPCS makes, that at the very least, at that time, the judge who's about to conduct the inquiry should solicit, and if the defendant wishes, obtain from him or her a set of questions that then the judge would ask the witness.
Well, I'd suggest that that procedure falls short of giving the defendant his right to a fair hearing on this issue. It'd be like submitting questions in writing to cross-examination.
Well,
I
if you
mean-
can't get that, if you can't get the hearing, what's the next best thing?
I'm
Look,
sorry,
if I-
I'm not sure I understand the
If
question.
we were to disagree with you and
Yes.
say, but we're going to do something, what's the next best thing in your view?
To allow the defendant to have a copy of the transcript subject to protective orders. That would be the next best thing.
May I ask you this? Is there any court that has adopted this procedure that you're suggesting, that CPCS is suggesting?
As a result of my research, I haven't found any cases at all that specifically involve
We
this
don't even know if
particular
other
issue.
courts allow Martin hearings, do we?
Pardon me?
Do you know if other courts across the country allow so-called Martin hearings?
Other courts have had in-camera hearings regarding
Regarding the privilege.
Fifth Amendment privilege.
Okay, let me ask you this. What showing was made in this case justifying the Martin hearing to begin with?
I'm not sure there was sufficient showing.
Yeah, I have that
That
question
there was-
ab
that there should have
initio
been a
here. I
Martin
don't
hearing.
see. I mean, no one's said anything in the
That's
brief.
her issue. That's, she
No,
can't.
no, but no. I
On the
mean, why
record-
wasn't just a regular colloquy held with the lawyer for the witness in open court? That's what normally happens. The Martin cases, the Martin procedure is only to be used in exceptional circumstances.
Yes,
So I'm asking, what exceptional circumstances were shown here?
I don't believe there were
Yeah,
exceptional
my reading of this
circumstances
case is that
justifying
that's the
in-camera.
problem to begin with.
Right.
But if you
Right.
don't get a Martin hearing, you get even less than you're getting here.
No, it's held in open. The normal hearing
Yeah,
is
but
held
you
in
add-
open court with the defendant is there,
Right.
the Commonwealth is there, the person claiming the privilege, the witness is there, and a lawyer is appointed for the person claiming the privilege, and everything is open.
Right.
So there's nothing that's hidden from you, and then you have no question about getting the transcript. It's
Well,
on the record to begin with.
discretionary. It's discretionary with the trial judge whether or not to have the in-camera hearing. I
Oh,
would
no.
suggest.
Well,
But there has to be.
Martin says in exceptional circumstances.
Yes,
It doesn't say in every case. And I'm asking, what was there here to justify something different from the normal procedure?
I don't think the record establishes
Yeah,
that
I
there
think
were
that's
sufficient.
the first problem.
So again, I do want to emphasize the point that this is the only particular situation where there's a Martin hearing that an issue would be appealable. The ruling by the judge regarding the Fifth Amendment would be appealable. If it's a Commonwealth witness, it's not going to be an appealable issue.
Not
either
in this
by the-
case, it's not, but it might be in the next.
But neither the Commonwealth nor the defendant has a standing to appeal that ruling by a trial judge. And obviously, if the judge rules in the defendant's favor, it's not going to be an appealable issue.
Thank you, Ms. Glass.
Thank you very much.
Mr. Ditkoff?
May it please the court, Joseph Ditkoff for the Commonwealth. With me is Mark Zanini. He was the trial prosecutor.
Can I ask you
Sure, Your Honor.
this sort of preliminary question? I understand that the witness in this case has no objection to a review of the transcript, right? I know it's done without the benefit of counsel. Does that make a difference?
That's what he told my investigator.
Right.
And, of course, at trial, he initially, when he wasn't represented, said he was willing to testify. And then once he got counsel, decided that he wanted to claim his Fifth Amendment privilege. So I don't know how far that goes.
But here it's a slightly different issue, and I'm really asking you to give me some help about what impact the lack of counsel has, because now it's just the record, right, that we're looking at. We're not looking at having another hearing, and I mean we're just looking at the record, correct?
That's correct, Your Honor. Presumptively, if the Sluman Martin hearing was held properly, there should be self-incriminatory statements of Mr. Gillum on this transcript. Now, of course, I haven't seen the transcript, and my position is I shouldn't ever see the transcript. But that's what
You have not,
I have not.
right? And you should never.
My position is I should never see it.
No, in fact, you don't want to.
Correct, Your Honor.
For very right.
Now, Mr. Gillum's move to Georgia, he may not realize that statements he made here could have effects that he's not anticipating, maybe in cases that are going on there, federal prosecutors. I certainly haven't run his current, Georgia record. I have no reason. For all I know, he's on the straight and narrow
Sure.
now. But even if, in this particular case, you have a witness who is now waiving the privilege or even has died, which is the best kind of waiver of the privilege there can be, the court still has to decide what's the sensible method for adjudicating a question like this, one where, under the Lewin-Martin process, the defense counsel aren't there at trial. They don't get to see what's going on there. And to answer Justice Cowan's question from the beginning, Lewin-Martin hearings happen all the time in Superior Court. What is a little unusual is they're not all that frequent as far as defense witnesses.
Okay, well, let me ask you this question. In Martin, it says, we agree that in these unusual circumstances, a judge has the authority to conduct an in-camera hearing where the witness was asserted his privilege. So what unusual circumstances were shown here to warrant, rather than a hearing in the courtroom, which is, as I understand it, the normal way? If a witness claims the Fifth Amendment, lawyers appointed, the defense counsel is present, Commonwealth is present, and in the courtroom, the lawyer makes an argument to the judge, or a few questions are asked of the witness. I'm going to claim Fifth, I'm going to claim Fifth, and then the lawyer says to the judge he's got a privilege, he's going to incriminate, he's going to subject himself to perjury if he testifies, or blah, blah, blah. But what here justified these unusual circumstances to conduct an in-camera hearing?
Well, to be perfectly frank, Your Honor, I think the judge jumped the gun on calling the Lewin Martin hearing.
So do I, and that's what jumped out at me from the record, that I didn't see, based on Martin and my experience, at least, and I certainly presided over a lot of criminal trials, and I took part in these things, but they're always done in open court, except, I guess, in Suffolk County.
But they're not asking what the evidence, what the witness's testimony will be, correct?
That's correct. That
Well, the
can't.
witness says that it's going to be the Fifth, and then the lawyer says that he can't testify because whatever the problem is. But that's the ordinary case, and Martin is positing an unusual case because it says in these unusual circumstances.
Yes, I think what should have happened is first the judge should have heard from, I mean, CPCS is exactly right that you're supposed to ask the parties, not just the defendant, the person presenting the party, what questions are you going to ask, but also the other party, what's your cross-examination going to be before you go anywhere. And then once you've done that, you hear a legal argument from the lawyer for the witness.
In open court.
He won't say what his client told
Right,
him his
right.
testimony would be. He can't do that because that's the self-incriminatory information. But I even think on this record, that's something we'll argue in the appeals court. Forget what's in that Lewin Martin, that sealed transcript. There's enough to show
I
the Fifth.
assume, I haven't looked at it, but I assume that part of what's in the sealed transcript is what the witness is going to testify to, and that's the problem.
That's what should be in a Lewin. That's what should be in a Lewin Martin hearing
Right,
transcript.
so
It's
that-
not for the
Yeah,
legal
in
discussion.
Lewin Martin, it was a victim, right? So it's the question is, what's the victim going to say? What's the witness going to say? And that's where you get...
But first it has to be shown that you need this hearing, and
That's
nothing in
correct.
this record shows that this hearing was necessary.
I
Error number one.
do agree with that.
Yeah, okay.
But it,
Can't we infer that, that I don't know whether it's on the record, but can't we infer that the judge was somehow informed that the testimony that this witness was going to give at trial would differ in material respects from the testimony that the...
This witness was a co-defendant who had fled,
Right.
so it wasn't clear that this witness testified before the grand jury. Right?
no, he certainly had agreed to a factual colloquy when he
I
pled.
thought he had testified before the grand jury.
No, he had not, Your Honor.
Oh, okay.
He
Oh,
was-
then
he was
I'm-
a co-defendant.
okay, yeah.
So I don't know
Well,
if
that's why you
infer
need
that.
this showing in the court before you even get to this hearing.
That's right. The judge should have determined. She jumped to the Lewin Martin hearing. She should have determined first whether just on what could be said in open court and the argument of counsel, not just witness counsel, all the counsel, whether there was a Fifth Amendment. Now, she couldn't say there's no Fifth Amendment plainly without listening to the guy, because for all you know, the answer would be, well, I wasn't at a drug deal because I was murdering someone. Then, I mean, I'm sure that's not the case
you
here.
have to
But
Yeah.
So let's assume that you're correct. She jumped the gun. Now we've got this case. It seems to me that we can deal with it in one of two ways. We can say 211.3 is improper, upholding the justice. I mean, we're really here looking at Justice Cordy's decision, correct?
that's correct, Your Honor.
The question is, what do we tell the appeals court to do so we don't just run up the flagpole? I mean, there is some judicial economy here. I mean, she's jumped the gun, but let's assume, I haven't looked at it, but let's assume that what's in that record is the testimony that the witness would have given, which this judge has now concluded would in fact violate his right.
Correct, Your Honor. That's what should be in there.
So what do we do now?
Well, we still, because it exists and because there is presumptively self-incriminatory material in that transcript, we have to decide how that's treated on
Correct.
appeal. The
Correct.
fact that the hearing shouldn't be held doesn't answer the question.
No,
of-
that's what I'm asking you to tell me what.
And first of all, as far as 211.3, I opposed the use of
Right.
211.3 in this
Right.
case, but at this stage, I
You want an answer.
I affirmatively recommend it. If my sister goes and asks a single justice of the appeals court, I mean, I've got cases in my
Right.
16L letter that's say if it wasn't seen below, it shouldn't be seen on appeal. But if an appeals court justice granted that, I would immediately take a 211-3, and maybe, well, we'd be back here again.
If what wasn't seen below by whom?
If there's stuff that was seen only in camera by the judge and not by any of the counsel,
Right.
when it gets to appeal, it's seen only by counsel. Not in a Lewin Martin
No.
sense, but in the old Bishop Fuller,
It's seen only by,
on appeal, it's seen only by the judges. If it was only seen by the judge,
she's already seen it.
I know, and I
Okay,
took
so
a 203
let's,
on
so,
that.
so we've got, so we put, there's a footnote in the opinion that says that shouldn't have been done. So you're saying what should happen in all of these cases, defense witness, Commonwealth witness, if there's a Lumen Martin hearing, you know, if you meet the threshold test in unusual circumstances, then what should happen is only an appellate panel judge should see the record.
That's correct, Your
Okay.
Honor. At the Lumen,
And
Doesn't that mean, though, that because the defense counsel, let's assume that, anyway, nobody can see this record in terms of counsel, that in every case, assuming that the witness was one that the defendant wanted, but in every one of those cases, there's going to be a request to the appeals court to an argument that we think the privilege shouldn't have been granted, you've got to review it and do that.
oh yes, Your Honor. I mean,
How often is it a defense witness?
it's
In
very,
your experience?
it's very rare.
Yeah,
Uh,
same, that's what.
This is the first time I've seen it. I don't know anyone else who's seen it in Massachusetts.
And
And
you were saying that there'd been, assuming that it's the Commonwealth witness, it's a determination at the trial court, with or without a Martin hearing, that's it. No,
I'm
that's
sorry.
it, no appeal.
I didn't hear
No,
the predicate. Your Honor.
If it's a Commonwealth witness,
Yes.
and you get over the threshold, there's a Lumen Martin hearing, no interlocutory appeal, nothing.
Under all but the most extraordinary circumstances. I can imagine some
Okay.
judge saying, I find he has a fifth because his wife will be mad at him if he testifies. And we could take a 211-3 on something crazy like that. But other than just something on the record and saying, correct.
Well, what if a defense lawyer says, with respect to this kind of conversation that's taking place at trial concerning a Commonwealth witness, said, Judge, I think, you know, there is no Fifth Amendment privilege here, and I think it's very important that I be allowed to question this witness because he has a lot of information that's going to be useful to my defense. Essentially, I can turn him into a defense witness, even though he's a Commonwealth witness. What about in that situation?
Oh, I agree with that. The defendant would then have a right.
You essentially you've essentially converted the witness into a defense witness.
Right. They're not Commonwealth witnesses, not defense witnesses. They're just witnesses. But as far as why this doesn't come up very often, is defendants don't call witnesses very often. They almost never are affirmatively asking for the testimony of a witness that's not friendly, because you don't know what they're going to say. They might
We
say.
assume the Commonwealth brings witnesses who may or may not be friendly to the Commonwealth's case to put on a fair trial.
Yes, the Commonwealth does that all the time.
Sure.
But the defendant rarely calls a witness that they haven't already talked to. And what's unusual about this case, and why this case actually happened, is that Gillen wasn't unfriendly. He said he was going to come in and
You say
testify.
wasn't?
He was not. He said he was going to come in and testify and waive his fifth, and it wasn't until they gave him a lawyer that he said, "Oh, this is not a good idea. I didn't think this
Well,
through."
since he had already pled guilty,
Yeah.
what?
Why did
just
he have a Fifth
theorize?
Amendment?
What could he? What would his Fifth Amendment privilege relate to?
Oh, I think it's pretty certain that first of all, he had a whole bunch of other drug cases pretty similar, and this is on the record around that time, and those are just the ones that we were affirmatively prosecuting. We surely didn't catch all 5 of his drug transactions in those 8 months.
So you mean something he might have said in this case might have it all happened at the same time, and he would be incriminating himself as to other drug transactions?
Not only that, but we would want to cross-examine on that if, as we assume, he would. I mean, it's all on tape, and he's admitted that he's done it. So presumably, what he's going to say is, "I didn't use Mr. Pixley," or maybe something about entrapment.
But you
And-
could question him about all kinds of other things.
I'm sorry.
You could question him about all kinds of other things.
Oh, that'd all be relevant. You don't use people in your drug deals, but what about all these other drug
Sure.
deals? And were there any other, what about your other drug deals that day? And that's where I think the fifth, which is why I don't think you even need a Lewin Martin hearing. I think that was patent from
Then you could
material.
have made a representation like that in open court, just like you did here in open court.
And Mr.
And the
Zini-
judge would have said, It's a valid Fifth Amendment privilege, that's, yeah.
And Mr. Zinni did make that representation in open court, but only after the judge had jumped to the Lou and Martin hearings.
Mr. Ditkoff, let me ask you this, and you may have taken a position against this. Do we allow interlocutory appeals or not? Or do we just let this come up as part of the defendant's appellate defense after the conclusion of the trial?
Well, as far as the ultimate question of was the Fifth Amendment privilege properly found, that's just going to be a normal direct appeal. But here we have the question of what's the procedure. And though I opposed it below, I certainly understand the position my sister's in having two different Superior Court judges basically give irreconcilable, both first session judges in Suffolk, in fact, irreconcilable orders to her, putting her in kind of a position. And while it could be adjudicated in the appeals court, it's not going to get better than the record we have now.
Yeah.
The
So-
irreconcilable orders are the first order of Judge Ballard, she could see it. Not Judge Ballard, Judge
Laureate.
Laureate, that she could see it, but then later that she couldn't, well, he said
Disclose
you
it.
can't copy it and you can't discuss it with anyone, so.
Well, what should happen if there is a legitimate Martin situation? There's a transcript that's prepared. Nobody's seen it. Should the defense lawyer ask to get access to it from a Superior Court judge, or should they do it on appeal?
No, I don't think the defense counsel should be able to see that at all.
At all, okay.
That's the
All right.
rule. But now the defense counsel does have a right to, is ask the appeals court, or if it's a murder case, this court, to take that transcript and to look at it in camera and do the same review that the trial judge did in determining whether there's a Fifth Amendment privilege.
Should the witness's attorney have an opportunity to argue before that appellate court, whichever one it is? Seems to me the witness has the most at stake here.
I think there's truth to that. Whether actually having them argue in an appeal would be practical, I'm not sure. Certainly allowed to be heard as far as briefing is something that should happen. But even that, you see how impractical it was here, where the witness is out in Georgia, and it was hard enough just to find him, never mind get a lawyer who could then talk to him. I know our CPCS budget isn't really going to accommodate people flying to Atlanta, though I have friends there I could set them up with. But it would be difficult. But certainly if a witness came in and said, hey, I want to be heard, here's my brief, whether you call that an amicus brief or a brief of an interested
but again,
party.
wouldn't you look at what's before the trial judge, right?
That's right,
I
Chairman.
mean the motion judge. Assuming that you get over the threshold, you look before the motion judge. I don't know whether the witness, is correct, is lying or not lying. I mean, that's not the issue. The question is there something there? And if his lawyer, in this case it's a he, gets, before the motion judge and says, look, there are all kinds of other circumstances, and let me suggest some of them. But even if he doesn't say that, he just says there are all kinds of other situations where my client has been involved with, drug dealing or whatever it is, and he's going to be subject to cross-examination. That's the end of the question, isn't it?
That's right.
I
Just
don't
as-
care what the witness argues on appeal or doesn't argue on appeal.
Yes, I mean, that's right. Under Francis, once there's a Fifth Amendment privilege, that's the end. It's not like Dwyer where you decide whether you're going to pierce the privilege. If you determine there's a Fifth Amendment privilege, end
That's
of
it.
case, they don't testify. I'm just saying if a witness wanted to come in and be heard to say, hey, my Fifth is really good, don't create a new trial where I have to testify, I think he would be heard. I don't mean heard in person, but would certainly be heard as in his pleadings would be read by this court or by the appeals court.
Thank you, Mr.
Thank you, Your
Bishop.
Honor.